I guess we'll start. I think if we had one less person, we could have done this in the bar. But we're going to go forth on Friday afternoon nonetheless and do it here in the room. I'm Steve Molo, partner in Molo Lampkin. We are a litigation boutique with offices in Chicago here, New York, and Washington, D.C. We do business litigation, white-collar defense, and intellectual property litigation, and we do that here in the United States for clients around the world. And we are involved in corruption issues, representing clients in corruption issues, that is. And so it was our pleasure to organize this afternoon, and hopefully inform you a bit with what remains of the day. Let me introduce the panel to you, which is a quite distinguished group that we have here. And I will say, at a distinguished group, perhaps most notably, and it's not just the fact that he has subpoena power and can indict my clients, but I will say the gentleman on my far right is Matt Miner. He serves as the Deputy Assistant Attorney General for the Criminal Division of the Department of Justice, where he oversees the work of the fraud section, which ultimately prosecutes FCPA cases, as we all know, and the appellate section. Prior to rejoining the Department of Justice, he'd been a partner at Morgan Lewis, where he had done government investigations and strategic government relations and counseling work. Before private practice, he served as the Senate Judiciary Committee's Chief Counsel for Crime, Terrorism, and Oversight, where he helped draft key pieces of federal crime legislation. He also served as an Assistant U.S. Attorney in the Middle District of Alabama, where he prosecuted a wide range of cases. Immediately to my left is Marta Carrera-Slabe, who is the Chief Counsel for Aon in Latin America. She's responsible for managing Aon's team of in-house attorneys throughout Latin America and advising the business on legal and compliance issues related to everything that's really going on in the region. Among her responsibilities are supervising corporate transactional matters, mergers and acquisitions as they relate to Latin America, and she has a unique and interesting perspective with respect to FCPA issues in Latin America. Before joining Aon in 2006, Marta was an associate at Sidley Austin, and before that, she was a television anchor at WCIU TV in Champaign, so her presentation will be the most polished of anyone's here. To Marta's immediate left is Pablo Quinones. Pablo is the founder of a brand new white-collar defense firm called Quinones Law. Before that, it's a white-collar boutique located in Midtown Manhattan. Before that, he was the executive director of the NYU School of Law Program on Corporate Compliance and Enforcement, the PCCE it's called, and he's now serving as a senior fellow of the PCCE as he devotes more of his time to his law practice. Pablo's got a great perspective and background in that he began his career as an assistant United States attorney in the Southern District of New York. He eventually became the general counsel of the company. He was a partner at Reed Smith, and before going to NYU, actually served as the deputy chief of the fraud section of the Department of Justice in Washington, D.C. So what I think is unique about Pablo's perspective is that he sees things not only from the practical and enforcement aspects of it, but also from a policy perspective, where he spent the last year really thinking about a lot of these issues that we're going to talk about and dealing with people from a whole lot of cross-sections in the business world and legal world as they sort through these tough issues. And then immediately to my right, my pleasure, is my partner, Megan Church. Megan, for those of you who are Chicagoans or read Chicago's Crane Chicago Business, would have seen this week that she was named one of the leading, what was it called? One of the notable women lawyers in Chicago. I would just say she's one of the notable lawyers in Chicago. I wouldn't qualify it with women. But Megan has been with Molo Lampkin for a year. Before that, she had a distinguished career as an assistant United States attorney here in the Northern District of Illinois, where she led the financial crimes unit. Before that, she had served as an associate for a short while at a large firm, and she had clerked for both the district court and the United States Court of Appeals here in Chicago. So with that, we thought what we would do is set the stage for this discussion with a little bit of a briefing on precisely what these statutes are, how it is that they come into play, and what their real relevance has been in terms of the enforcement activity, the statistics that have been there, and Megan is going to do that.
Sure, to start things off, and to give you some perspective on the numbers. In 2017, 11 companies paid over $1.92 billion to resolve FCPA matters. And in 2017, 8 individuals received criminal justice sentences ranging from probation up to 5 years imprisonment. Another 12 individuals were convicted of FCPA-related offenses, and 7 more were indicted. So the stakes in the context of the FCPA are very high. FCPA violations lead to enormous judgments and settlements that companies must pay out, and people actually go to prison for these offenses. And so these are very serious violations, very serious investigations, and they all have serious consequences. So to start things off on what the FCPA is, for those of you who don't necessarily have the background on the Foreign Corrupt Practices Act of 1977, it was enacted by Congress in the wake of the Watergate scandal and in response to revelations of widespread bribery of foreign officials by U.S. companies, essentially to win business. On top of that, it was discovered that some of these U.S. companies were also using slush funds to pay illegal campaign contributions as well as to obtain foreign business. And the FCPA was meant to stop those corrupt practices, to create a level playing field for honest businesses, and to restore public confidence in the integrity of the marketplace. And for a long time, the FCPA was not necessarily enforced as vigorously as it is today. And so over the course of the past 10 years or so, FCPA enforcement has skyrocketed, leading to these billions of dollars in settlements and judgments. And the FCPA has 2 provisions that really govern investigations and resolutions in this case. The 2 provisions are the anti-bribery provision and the books and records provision. So the anti-bribery provision prohibits U.S. persons and businesses from making, promising, or authorizing corrupt payments to foreign officials to obtain or to retain business. And payments can be virtually any benefit and don't necessarily need to involve an exchange of money. And there's also no threshold for what constitutes a bribe payment. It can be almost anything. And it can include things like payment of expenses and payment of travel. Even the smallest bribes are prohibited. It's also worth noting that the bribes don't actually need to be paid to constitute a violation of the FCPA. The offer or the authorization to make such a payment is also prohibited. And it's worth noting that quite often, and actually most often, it's payments via third parties that get corporations and individuals into trouble. You cannot have an agent make the payment for you or for a corporation. That's also prohibited. And the books and records provisions require public companies to make and keep accurate books and records, and then also to implement and maintain an adequate system of internal accounting controls. Unsurprisingly, they also prohibit individuals and businesses from falsifying their books and records. So the anti-bribery provisions are enforced essentially through the books and records provisions. And in case you did not know, both the DOJ and the SEC share enforcement responsibilities, and they collaborate often in these investigations. The FCPA defines foreign official very broadly. So it's not just an individual who happens to work within a foreign government. It includes people or entities performing government functions, government contractors, government advisors, and even employees of international organizations. The FCPA also applies broadly to those with formal ties to the United States, including U.S. citizens and corporations, and then also to individuals or corporations that take action in furtherance of some sort of bribery incident within the United States. And so U.S. corporations and individuals can be held liable for bribes paid to foreign officials, even if no actions or decisions about the bribery actually occurred within the United States. And even over the past several years, the DOJ and SEC have charged and prosecuted a number of foreign corporations for bribing non-U.S. officials. So the jurisdiction of the FCPA for enforcement activities is enormous. As are the penalties. They're extraordinarily significant both for corporations and for individuals. Corporations can be fined up to $2 million for each violation of the FCPA. Individuals can be fined up to $250,000 and be sent to prison for upwards of 5 years. On top of that, corporations are being forced to pay back their ill-gotten gains, which is in part why you see these enormous settlements with corporations that range upwards of hundreds of millions of dollars. And what may come as a surprise to some companies is they may be forced to hire and pay for an independent monitor to ensure that they have the appropriate compliance procedures in place to ensure that no future violations occur. These are some of the highest FCPA resolutions over the past few years. And you can see, as of 2017, the highest was almost $1 billion. And ranging over the last few years, these settlements get higher and higher and higher. In part, and as I think you'll hear about today, there's been greater collaboration among international enforcement regulators to make sure that each country that's involved in working together and collaborating on these investigations gets its appropriate share of whatever the ultimate resolution is. And finally, this is what the overall statistics look like for FCPA enforcement over the since 1978 through 2017. And you can see the uptick over the last decade or so in FCPA-related activity. And it doesn't look like, even if there is a slight diminishment from year to year, because these cases take years to investigate and ultimately resolve, that there is a consistent theme of an onward progress to enforcing these, to enforcing the FCPA and ensuring that there is no bribery, or trying to limit the amount of bribery that occurs in the United States and abroad. So now we can turn to FCPA enforcement and compliance under the Trump administration.
So you saw those statistics, which are really astounding, and you see that this has been a steady trend that has developed over the last 10 years, where enforcement of the corruption laws, not just in the United States, we're going to talk about this, but throughout the world, has really grown. And the topic of this program is enforcement under the Trump and compliance under the Trump administration. So we have with us the Trump administration, at least as far as enforcement of the FCPA law goes, in the form of Matt Miner. Matt, is DOJ's position on FCPA changed now under the Trump administration, or is there going to be a pullback, or are we going to still see, you know, this level of enforcement? Because these cases that Megan was just talking about were cases that had been instituted and worked up over a period of years and culminated in 2017 before you all took office.
So speaking in just in terms of prosecution policy and approach to the FCPA, there are some changes in terms of policy focus that I'll talk about, but largely we're looking at continuity. And if you think about it in terms of what the policies are that have been announced and rolled out under this administration, for example, the corporate enforcement policy that is a continuation in a way, with some changes, of the FCPA pilot program from the prior administration. If you look at the numbers in terms of individual prosecutions, which we will probably talk about more during the discussion, individual accountability of wrongdoers and corporate executives who are complicit in bribes, even public officials who were using the U.S. monetary system to launder the proceeds of bribes, they are being held accountable. And the numbers of prosecutions for individuals are up last year, and the numbers are also high this year. So in terms of the focus and sort of the priorities, how it might change, or emphasis might be a little bit different, not speaking to dedication to enforcement, I think that is largely a continuation, will still be there. The appetite to pursue corrupt conduct that impacts U.S. businesses, U.S. markets, and abuses the U.S. financial system is still going to continue. But in terms of the different focus or where the priority areas are, I think you've seen in terms of the policies that have been announced an effort to really continue, but also emphasize having a little bit more in the way of clarity in the policies and their application, so that the business community and individuals in the bar have a better understanding of what, for example, a voluntary self-disclosure will yield, and cooperation, and you can see that through the corporate enforcement policy. So being more transparent and being more open about what is expected, or what the incentives and rewards might be from the department through that cooperation. That includes as well making public declination decisions so that the criteria underlying those declinations can be examined, not just by lawyers, but by in-house counsel and outside counsel advising boards and corporate general counsel as they make the very difficult decision once misconduct is identified. What are we going to do with this? Secondly, and this is again a continuation of some of the efforts and focus from the last administration on focusing on individual accountability, and of course that goes back to what was present in the U.S. Attorney Manual and the Philip factors as well. Individuals were always to be held account, but if you look at the numbers and the prosecution numbers, those numbers continue to be very strong. 2017, there were 21 individual prosecutions, or well, not prosecutions, convictions or pleas of individuals in FCPA cases. That was higher than the next highest year by a factor of 2. And this year, I believe there are 10 individuals who have either pled guilty or been convicted. So the numbers on individual accountability are strong. Again, it's a continuation, but it is a priority area of focus. And then a continuance of really a policy focus of the FCPA, which is leveling the playing field for law-abiding businesses that want to compete in markets around the globe. There's an emphasis on that, and the international cooperation with other countries to partner with those countries and also encourage more robust enforcement of corruption in those markets helps to reinforce that leveling of the playing field. So that is an area of focus that as well continues and goes all the way back to one of the core goals of the FCPA. But those would be sort of the 3 priority focus areas that that this administration, this Department of Justice, and Deputy Attorney General Rosenstein has outlined in his speeches over the past year and a half.
The pilot program that you referred to instituted essentially almost a presumption of declination with self-disclosure. I don't know if that's a fair statement, or at least it was a very, very favorable consideration. Is that something that's been adopted now still in the final changes?
So in terms of the corporate enforcement policy, that adopted a presumption of declination absent aggravating factors. The pilot program said that there may be a declination, so it was something that would be considered, but it wasn't something that was a presumption. And so the corporate enforcement policy was an effort to make the incentives or the outcome a little, not certain by any means. There are always going to be variables that need to be examined and in the facts, but more concrete in terms of what the outcomes might be. And so the declination with disgorgement, absent aggravating factors, and those would involve things that would trace their way back to the traditional Philip factors: high-level management involvement, pervasiveness of the misconduct within a corporation. Is this how you were doing business in a way where corruption was rampant through the organization and its subsidiaries? Similarly, a large amount of profit that might have been derived from the wrongdoing, and of course, recidivism is something that factors in as well as not just an aggravator, but it really takes a corporation outside of the declination eligibility. If you're
so by creating this greater level of certainty, the idea is that a lawyer advising a company is going to have a better set of guidelines to be able to help that client make judgments. Right?
Exactly. Yes, I think you paint the lines, and it helps people to know how to act. It's a classic example. If you think about criminal law at a broad policy level, it's intended to deter wrongful conduct and encourage law-abiding conduct. And policy should do the same thing, really to make clear what it is that the department would most want and expect a responsible corporation to do. And if these actions are taken, here are concrete incentives that will tie to those. And to the point on certainty as well, I think one thing that was done in the pilot program was really tremendous. I know Pablo, when he was at the department, worked on that as well as the corporate enforcement policy development. But one of the things that I think really helps is taking things out of a temporary pilot that operates on a period of time, and it needs to be extended, and instead have it be made permanent in the U.S. Attorney Manual. Things in the U.S. Attorney Manual can be revised over time, but having it in the U.S. Attorney Manual removes the temporary nature of the pilot, and so there's a greater reliance on the policies, I think.
So Pablo, does that make it a no-brainer then, essentially, for a company that's faced with this issue. The allegations are brought to light. They've been investigated to at least a certain degree. They learned of this. Is make it a no-brainer then to go and report it to DOJ?
Unfortunately not.
Why
It's
not?
not. It's not a no-brainer. There are probably a couple of sort of main overarching reasons that I would think about. One is internal to the policy, and the other is external to the policy. Internal to the policy, there are portions that are still going to be uncertain. How it is the aggravating factors are being assessed by the government are going to leave many companies wondering whether it's worthwhile to take the risk or not, that the government will view those aggravating factors in a way that benefits the government and not the company. And that's something you want to know before you decide to go in and essentially confess. Beyond that, you're going to want to know sort of what the government thinks a recidivist is. There are many companies that have various kinds of exposure that come up in civil contexts, others in regulatory contexts, others in criminal contexts. If you're seen as a recidivist, then you're not going to be entitled to the presumption of a declination. And
Well,
you may
one
not
person's
get,
recidivist is another person who just had a misguided youth. Is that right? I mean,
and maybe if you were a company, that would apply sometimes, but it'd be hard. So it would be challenging to sort of assess those factors as well when you make the decision. I think on the external sort of factor to keep in mind is the policy when it was announced both as a carrot and stick approach to FCPA enforcement. So the stick, of course, is an increase in enforcement. And if companies don't believe that they're likely to have cases brought against them, that the focus will be on individuals, then the likelihood that they will go in and disclose conduct that is not likely to get found will also likely decrease. So I think that you get sort of overarching issues that come into play that not only don't make it a no-brainer, but may lead many companies to decide it's not worth the risk.
so that's all. We're talking there all about things that have occurred once the company has discovered the problem. Let's assume there isn't a problem that you know about right now. I mean, are there incentives, Marta, for a company to go through and investigate their internal practices, revise them, look at their compliance program with respect to FCPA if they haven't really run into issues so far?
Absolutely. I mean, I would even argue, even if you have an internal problem that you've discovered, and you go to external counsel, which you absolutely should, and get their advice, and you don't end up reporting, you still need to investigate internally. I mean, you need to look under the rocks. You need to be able to establish that perhaps you used your internal audit function, you used your internal compliance and legal function, you investigated, you looked at emails, you did everything you could within your power to remediate the situation and to confirm that it's not something that is that it's a one-off or not something that is happening consistently throughout the organization. So I think either way, if you find something, it's obligatory to investigate internally and to be able to, God forbid, if somebody does find out external to the company, to be able to tell a good story about what you did. To your previous question is a loaded question. It's a huge question because, of course, absolutely, Megan mentioned in her introductory comments about FCPA having two prongs, essentially, books and records, and then, the illegal behavior that you bribe somebody to get an unfair commercial advantage. And where companies, I think, have been bare for a long time have been on the books and records and the compliance programs, and imperative to have a program that's really meaningful. It's very easy to put a web page up to have policies and assume that everybody's read it and therefore understood it. And in our company, especially in Latin America, I mean, we in-person training, constantly drilling down. Even as the program has matured and developed, a much more targeted training that looks at compliance overall from a risk-based approach. So not just any third party, but a third party with a government client in a particularly high-risk jurisdiction versus a third party who's licensed and is in a medium-risk country, and there's a per se reason why that third party is there. And lastly, I would say, and I know we'll talk about this later in the presentation, that from where I'm sitting, we've seen a lot of issues percolating lately that are regulatory issues. So we see a lot more activity. We are a regulated industry. We're insurance brokers, and we see a lot more activity, particularly in Latin America, from regulators that are coming to see what payments we've made to unlicensed third parties and asking all sorts of questions around it. And it could be that there's no corruption problem at the end of the day, that it's just poor documentation, but you start pulling one string and that leads to unraveling of the entire fabric.
Are there, from somebody in your position, you've got a global business, are there sort of big picture items that, sort of are at the forefront of your mind that you're thinking about before a problem arises?
Oh, absolutely. I mean, so third parties, and it's particularly unlicensed third parties. In our industry, we're looking at introducers, producers, individuals or entities that bring you business or are in the commercial chain and aren't able to articulate any value. And as you can imagine, this is a bit of an art and a science, because in a professional services industry like ours, there is a per se value in the relationship and access to the C-suite at the client's organization in order to open the door and be able to get business. But it's really unraveling those relationships. I think it's a meaningful program when the business sponsor is part of the review. I think for many years it's become a check the box exercise, and I know we're going to get to this a little bit later, but the business has to own it and understand that if they're going to go aviation or if they're going to go to a government-owned airline or oil and gas in a high-risk jurisdiction, hell, even a medium-risk jurisdiction or low-risk jurisdiction, there's certain industries that are prone to corruption, and they need to go in eyes wide open and make sure they're taking a reasonable approach and doing the appropriate due diligence.
So what we've been talking about now has been activity that's occurred in sort of the ongoing operation of the business, and I think that's the way most of us think about FCPA in the immediate enforcement context. But the corporate enforcement policy doesn't really talk, Matt, about mergers and acquisitions, where a company's going to go out and do an acquisition, and the businessmen and women in the company are all excited about this is going to become, a great thing from a business perspective to acquire this other company. And in the diligence process, they learn that the company being acquired has engaged in corrupt activity. They've been paying bribes to someone or some entity. There's no real discussion of that in the corporate enforcement policy, and it seems to be a little different than the situation where the company has learned of this occurring in its ongoing business operation.
Thanks for that question, Stephen. I think that there is value in clarifying that point. Prior to the FCPA pilot program and the corporate enforcement policy, there were some provisions in the FCPA guide that was put out by DOJ and the SEC in 2012 that spoke to some provisions that will allow due diligence in mergers and acquisitions context to be either reported to the department and worked through in terms of things that are identified in post-acquisition due diligence, how those are going to be addressed, how compliance is going to be rolled out, and as well the opinion procedure. So if in pre-acquisition due diligence, before actually closing a transaction, issues were identified and the company still wanted to move forward but wanted to have greater clarity from the department about whether consequences might follow, the company could come to the department, lay out exactly what the plan was, including that any component or business that might be inherently tainted by corruption and by foreign bribery, that those would be set to the side. In terms of the opinion procedure and the post-acquisition disclosures, they fall within the corporate enforcement policy. So the eligibility for a declination with disgorgement applies for those disclosures as well. It's a lot, I think, cleaner to apply it in that context because you're talking about an acquired entity as opposed to legacy conduct from within a company where it's been operating inside of the company, and instead you discover this from an acquired entity, and what do you do with it? And I think, and I don't want for there to be any uncertainty about it, because if you look at the 2012 guidance, it talks about how there may be a declination. There may be a decision not to proceed, and yet the corporate enforcement policy makes very clear. There's a presumption of a declination if you come in, you self-disclose, you remediate, and there's full cooperation. The same principles would apply. And with regard to the opinion procedure, I want to highlight that can be incredibly beneficial on the front edge, but it hasn't been used as much. It's been 4 years since it was last used. And I don't know how much of that ties to the fact that the incentives seem less concrete after the pilot program and the corporate enforcement policy were announced, or if it's simply a matter of, as Pablo and Marta were talking about, risk tolerance on the front edge. Do you want to come in and disclose something, or is it a concern about will we be able to close the transaction during the period of time that the opinion procedure may take to conclude? On the last point, I can say it does take a little bit of time for an opinion to be generated. If there's a discussion about what the timing needs are, we can try to expedite that opinion. Within certain obvious restraints you have to make sure are constraints. You have to make sure that you're giving good advice and considering all the facts. But I'd also say that in those circumstances where everyone is in a tremendous hurry to close a deal in a high-risk market where there are known issues flagged in due diligence, it might be worth it to pump the brakes a little bit and then get the guys.
It's not always easy for those of us advising corporate clients to get them to pump those brakes. That's the problem. What does an opinion look like, though? Because, I mean, let's break it down to what we're actually talking about here. We have a company that is acquiring another company, and they've learned that the other company, right, the company being acquired, has engaged in corrupt conduct. So as of that point in time, they have no liability themselves, all right? If they go forward with the transaction, the conduct continues, then they would definitely have liability, potential liability, if it were found out and prosecuted. I mean, so what is this opinion going to say? I mean, what does a favorable opinion say? What does an unfavorable opinion say?
Well, the 2014 opinion is a good example. The company reported that it had identified some indications of payments in the entity to be acquired. It laid out a plan for addressing and investigating the conduct, rolling its compliance program and controls out into the acquired entity, and a plan with regard to the specific business that had been acquired through corruption, to terminate that business as part of the transaction and to really sort of wall it off so that that would not be part of the ongoing operation of the business once acquired. The opinion from DOJ said, in view of these facts, we would not, assuming that the schedule worked in terms of rolling out compliance and everything and it was accurate, we are not inclined to pursue prosecution on these facts. So you can come forward, you can describe it, and you can get a level of certainty as to what DOJ will do on the front edge if you identify these things through pre-acquisition due diligence. But I want to be clear that on the post-acquisition side, that's actually trickier, because on the pre-acquisition side, you only get so much of a view into the entity to be acquired.
Right.
Once you actually get in there, you may find
it's much worse, yeah.
And that's where I think knowing that the corporate enforcement policy is available and the declination is available, the presumption is, should give a certain level of comfort to those once they've entered into these transactions and they stumble upon this. What do we do now?
So, Marta, you're in a situation where you're advising this hotshot executive who's looking to make their number for the year and become an even hotter shotter executive by acquiring this other company. I mean, and you're doing it in a jurisdiction, just to pick one that happens to be a high risk jurisdiction, Brazil, where the corruption seems to be sometimes almost a national sport or something like that because of Lava Jato and all of the great scandals that have occurred there over the last several years in particular. I mean, you're looking at a company, you recognize that you're in a high-risk jurisdiction, you're under pressure from this executive to get the deal done. And by the way, if the deal does get done, it's a good thing for the company. I mean, you're going to increase your revenues, you're going to increase your footprint globally as to this line of business. I mean, what do you do to, one, slow down the executive, and two, how far can you, stick your nose under the tent to find out what is really going on, to Matt's point? Because you might just see a little bit and you run over to Matt and say, hey, Matt, remember we were on that program, you said if I came and told you about these things, you'd give me an opinion and you'd say it's okay and go forward. And Matt said, well, I didn't quite say that, but I will tell you that.
Is that black and white?
Yeah, you need to know a little bit more. So what do you do? How do you deal with that situation?
So We deal with situations like that. So look, I think the reality in the corporate world is that people fall in love with the target, and once you're pregnant, you're pregnant, and you just end up, you speak up. The short answer is you speak up. In my position as in-house counsel, we have to get right in front of that hotshot executive and just talk to him and tell them what the risks are and try to find out as much as possible before close. Now, that's easier said than done, because the reality, I think, in the corporate world is people fall in love, they want the target, they run the metrics in a very cold, analytical, share buyback or buy the business. If I don't buy it, the competitor is going to buy it, and then I'm going to be out of luck. And then really a lot of the focus becomes on integration, post-close. So it is just paramount to speak up and start looking under the hood pre and post-close. I think, practically speaking, to your point, Matt, about why you don't see more companies coming forward, I think it just happens. The speed of the transaction is really fast. And if it is a problem that is that magnitude, you try to obviously stop the purchase from happening. We're a publicly traded company, so that hotshot executive is going to have to go to the board as well and get board approval. But I do think this is a place where companies are a bit vulnerable, because we've got, there's a tendency to have an M&A group. They look at a target. They look at it with blinders on, because it's share buyback or what the target's going to bring to the commercial equation. External counsel comes in that may or may not know your industry, and they're also looking to close the deal. The data room goes up. It's going to have insufficient information. In Brazil, it's going to be all in Portuguese. So unless you have really a good partnership between external counsel and in-house counsel that knows your industry, knows where to look for problems, and has been there, I think you are really vulnerable to a lot of risks post-close.
It becomes, really situational and relationship-driven at a certain level, doesn't it, in terms of how far you can go with that diligence? Because, you're in that spot where you want to look, but you don't really want to look, right? Or at least the executive doesn't really want you to look. But even as the lawyer, you're kind of hoping that you're not going to find anything. Do you think there's any sort of guidepost? You spent the last year talking about these issues with all sorts of people from all kinds of corporations, but dealing with these very, very specific issues. I think this is one of the most baffling issues in the whole FCPA area.
It is. It's a very difficult issue, and it's easy to sort of think about how difficult it is simply because many companies, even without mergers or acquisitions, have their own internal FCPA risks that they don't know about. Yeah. Right? So the idea that you could live in your own sort of suit and not know that there's something wrong with it makes it even more difficult when you're about to step into somebody else's, right? And you're going to find something there that may take you some time, may take you a lot of time, especially if you're trying to integrate that business into your own business. And as you do that, you begin to unpack their business in ways to reveal things they may not have known either, right? And before you know it, you're stuck with a huge liability. Now, is the government, I think, clueless to that fact? My answer to that would be no. I think the government realizes that, there are going to be many times where if a company itself has not uncovered the wrongdoing and the outside acquirer uncovers it, that there's probably going to be some benefit to that company by coming clean, right? Because ultimately I think the government wants to encourage that conduct, right? If you're in a scenario where it's the outside entity that discovers misconduct and they want to disclose it to the government, I think that's the match point. There should be a benefit for that, and that's ultimately where I think the direction is going to be. Does that mean that, companies run in on a merger and acquisition and self-disclose? Still, maybe not, right? You still have to consider the same factors. How long after you acquired the company, right? How long have you had this problem on your shelf, not on the other guy's shelf? Why did it take you as long to find it, right? Did you have people that integrated the compliance program, saw it, but then turned away because they didn't want to bring it up to the executives, because they didn't want to bring the executive down from his high that he just acquired the next big thing, right? So they're going to
the next big problem,
right? Yeah. Right, but they don't want to be the person that presents a problem, right? So you're going to have a lot of issues that sort of percolate like that are just going to be natural human instincts and behavioral factors that impact whether that event gets brought to the right people.
And what I was saying, go ahead. I'm sorry.
Yeah, whether it gets brought to the right people and in a way that allows them to make the right decision.
That's why I say a lot of it is really kind of situational and relationship driven. And you're also in this very awkward dynamic in the merger and acquisition context where you're not yet this one company, right? So you're still opposing parties, if you will, and you have learned that this other company has engaged in criminal conduct. You haven't. So you're going to go now report this other company's conduct to the DOJ and, still hope to get the deal done. That can create some, getting the deal done. Somebody would be willing in many instances to pull the plug and say, you can't do that. What do you do in that situation? That's a really tough situation where someone says, I'm prepared to walk away from the deal. You now have this information, but you don't really have any liability, right? Because you are an industry participant, but you're not a participant in the bribery. You know that maybe someone else is engaged in conduct, but they've now walked away from the deal. Is there any risk to a company there?
Well, it depends on if you're going to continue doing business with the entity. A lot of times the acquired entity is someone who, or is an entity that had business relationships already with the acquiring company. But if they're completely independent and the conduct's happening somewhere else and it's an independent company, I don't know if there's any obligation to report it if you're not going to go forward. But I will say this: the Big Four, I can't remember which one, did a study a few years back on U.S. corporations and the percentage of corporate boards that had backed away from deals in high-risk markets, and it was a very, very high percentage, had walked away from deals, possibly on exactly that set of facts. Now, thinking about it from the perspective, sort of policy perspective at the Department of Justice, we don't want to discourage law-abiding, well-structured, compliant companies from entering into transactions when another company that is not dedicated to compliance and is willing to embrace those risks and maybe continue the corrupt conduct will enter and acquire that entity, and the corruption continues. So we don't want to deter the good actors from going in, and the opinion procedure lends sort of a lifeline, or at least an ability to enter into those transactions with a little bit more guidance and certainty and comfort, and gives a tool to MARTA and others in the in-house community to say, look, we can do it. This is the process, and then pick up the phone and say to Dan Kahn and the FCPA unit, okay, how fast can you move? Because we're on a tight timeline. We want to move forward, but we've run into some risk factors, but we still think it's worth moving forward. So it's a tool to allow those compliant companies to move forward in these transactions, to allow companies to grow and not be deterred if they feel that the risk doesn't overwhelm the deal. And there are going to be those occasions where the risk is such you say, gosh, I think the entire business line is built on corruption, and they step away for that.
Well, and it's interesting too, because it's we think about these problems often, the ones that you read about in the Wall Street Journal and the New York Times, on a sort of large public company transaction basis. But the reality is, this issue is out there. We have a number of private equity clients that are acquiring, much smaller businesses that and deals that are not, public deals, and the risk is still there, for them as well too. It's in those situations they might want to come to you even on a no names basis where the transaction hasn't been in the news, like it might be if Aon is going out and acquiring some big broker, and they actually have an obligation as a public company maybe to even make an announcement under the securities laws about what they're doing. But if it's a private equity client in that sort of situation, would you do it on a no names basis?
Well, I think that as the transaction is approaching completion, you would want to know what the entity and the names are. But in terms of understanding on the front edge, so that a company comes in and says, we have all this information about company X, and they rather than me anonymizing it, actually is a real entity with a real name. I don't think in the early discussions that's called for, but I do think in order to make sure that post-closing of that transaction, the assurances in the opinion match up with what actually was described, you would want to have an understanding.
Want to have a bit more detail, I would think. What we've been talking about, sort of the enforcement approach, on the company side, what are some of the state-of-the-art compliance practices now? Going back to the enactment of the sentencing guidelines, where you had to have an adequate compliance program. There were the 7 boxes that got checked, and you had a code of conduct, you had a hotline, and when something bad happened, you said to the government, see, we're a good, honest company, tone at the top, we had a compliance program, give us a pass. Is it more evolved since then?
I don't know if it's more evolved, but I think you learn from your mistakes and it becomes more mature. I think in the M&A space, it is really important to have in-house counsel that speaks, if it's Brazil, that speaks Portuguese on the ground as early as possible in the due diligence process. There is no substitute for that, and you should not let your M&A corporate development team tell you that they've got it all well in hand and they understand it, because I think they are driven by share price and other metrics and not necessarily what's going to happen post-close with the integration. I think you absolutely have to ask for a client list. You absolutely have to ask for a third-party list. I think the target will try to tell you that, that's too much, especially maybe in a country like Brazil. But, even Brazil has the Clean Companies Act. And even Brazil has gotten religion and is learning from their own mistakes. I don't know that I would go ahead with the transaction if I didn't have a third-party list that I could run through an OFAC check. I mean, we're talking about anti-bribery, but if you find out that, a percentage of the book is a prohibited transaction because you're a U.S. publicly traded company, you just affected your share price. And I would think your CFO and your M&A team would want to know that right away so they could adjust the price. I think there's some things you can do to take a risk-based approach to the due diligence, pre- and post-close. It's public information, we had a large acquisition in Brazil where we had 1,500 third parties, and we engaged a vendor to help us do just some real high-level due diligence on the names to make sure they didn't show up in any public databases. We did some reputational checks, some background checks, OFAC checks, tax. A lot of times you can do due diligence, you find out they have a tax problem and you dig a little deeper and you see there's there's some bad practices with the tax problem, and that gives you an insight that you otherwise wouldn't have. I think these data rooms are hard to navigate because the target doesn't always want to give you the information you need, or you get contracts in a foreign language that are very, simple, will not have anti-corruption clauses, for example, and then post-close you're going to have the job of having not only to review those third parties but amend the contracts. And lastly, I will say there's no substitute for being on the ground in person and interviewing the target's principals. At a minimum, so you can get a certificate from them and then help cover yourself later. But just interviewing, somebody in-house actually interviewing them that knows your industry and asking them some really pointed questions face-to-face, building the relationship, doing everything you need to do so you get your answers and you're smart about it. At the end of the day, if you do buy the company, that's going to be your new internal client. So that really important in the due diligence phase and afterwards if you don't have the opportunity to do it beforehand.
So Pablo, outside of the M&A context, again, this last year you really focused on these very issues. What would you say the state of the art is? Sort of the new cutting edge things in terms of compliance. What is it that companies should be considering?
Definitely some of the things that Martha said extend outside of M&A as well, but something that we've seen that I think is valuable, and more companies are doing it, is targeted training. Sort of identifying sort of the particular risk associated with an employee going to a particular high-risk country to engage in a transaction that may itself be high risk, and targeting the training for that person close in time, and it being specific to the nature of the service that they're going to perform in that country, as opposed to having your single FCPA training at the beginning of the year where they may or may not pay attention for the entire training. They may tune out, they may forget it by the time they leave, and it isn't as valuable to them when they need it most. So I find that very helpful. The other thing that a lot of companies are doing is incorporating more data analytics into how it is they manage their compliance function, so they can identify where the risks are and then what needs to be deployed in order to address those risks.
What's an example of that?
Happens in a lot of different ways. I've seen it in circumstances where contracts are entered in a particular country and they look for abnormalities in the size of those contracts to see if some outlier is actually a reflection of probably misconduct rather than just a good market.
Okay.
Right? So in order to do that, they need to collect the data, they need to assess it, and then they have somebody say, you know what, before we even approve this contract, this seems like an outlier. Let's do some extra questioning about this contract, right? Rather than just let things go through and then figure it out later. Now that's sort of very proactive, but it also minimizes the chances that the outlier is fraud, right?
And as a practical matter, that's going to make a big difference if someday you find yourself at Matt's doorstep and you're saying, look, we had this problem, but you ought not prosecute us because we actually are an honest and ethical company. We do take compliance seriously, and we have more than just that code of conduct and a hotline and tell people don't commit crimes. We actually have a very precise and calibrated program that addresses things geared to our business and the specific risks that our business is in. Is that right?
I think that's totally true, but I think that also depends on the reason for why you're talking to Matt in the first place, right? So if the reason you're talking to Matt in the first place is related to training, then that's a very meaningful discussion, right? But if you're not talking to him in the context of wrongdoing that is a result of training, but perhaps some other deficiency, then it's very hard to sort of point how great you were at training when the other deficiency is what caused the problem, right? So you have to not just sort of be focused, but I think you have to be balanced in the way your compliance program is developed. And it also has to be dynamic, right? Because your business changes, the risks change. And ultimately, if you find yourself before Matt, it's a hard sell because you're there with misconduct in hand. So he's got the upper hand, right? Because something happened already.
But, I think he has the upper hand, but if in fact DOJ is being intellectually honest and being, honest with the public and saying that we will consider these factors, those kinds of things do have to make a difference, don't they, Matt? I mean,
they do make a difference. And no compliance program, as you look back on a violation, is going to be viewed as having been absolutely effective because something happened. And so in evaluating the adequacy of a compliance program at the time of the offense, you have to consider, had changes been made, had there been improvements, were there controls in place, was this a gap that was exploited, was there a concerted effort to thwart the controls, were there false certifications? There are a lot of different ways that people can work around a compliance program and the controls that are in place, but if those are identified and then there are remedial steps taken, and it's a compliance program and there are controls that are constantly being evaluated for risk, and you do have, it's not static. I think that is going to get credit. And in a recent speech on this point, the Deputy Attorney General talked about how compliance as part of the Phillip factors, we're going to look not just at the compliance program and its adequacy and effectiveness at the time of the misconduct, but also at the time of the resolution. So have things improved? What is that continuum? Were changes made and as lessons were learned? And so at both points, there's going to be an evaluation of the compliance program. And I think it's long been recognized that no compliance program is absolutely going to catch everything. What we want is a compliance program and controls that are risk-based, that are designed to be adequate and effective, and are in line with what the company's risk profile happens to be at that time. So if you have a company that designed something before acquisitions that then drove it into high-risk markets and nothing has been updated, the controls haven't been rolled out in one finance system. Let's say you've got 2 or 3 different legacy finance system, and in the SAP system, none of the controls have been built in. Those are the sort of gaps that are going to come to attention and come into focus. But if as Pablo was describing, a compliance program has been designed and you have targeted training and you have an analytical approach to transactions such that they're being scrutinized, that compliance program is going to get a lot of credit and a lot of weight.
Go ahead, Mark.
I would just even add that if you have a compliance program and you don't have any problems, that's a huge red flag.
Yeah, that's right.
I mean, human beings are human beings, regardless of what country they live in. Not everybody in a high-risk country is corrupt. And I think one of the pitfalls for publicly traded companies is that, we all use Transparency International Index, and we all cut off the world into low, medium, and high. But we conveniently, ignore, for whatever reason, that corruption does occur in low-risk countries. And in certain ways, I have it easier in Latin America because everybody just assumes everything south of the border is corrupt. And so the controls and review that we have in place is much more strenuous than the rest of the world, is stricter. So I do think that's sort of going to morph in the next phase of compliance programs is, you could have a French third party that's doing business in Mexico, or a French third party that's doing business in Canada that could lead to corrupt practices. It's not just that it's only Mexico, Argentina, Brazil, and
Or a
Venezuela.
French third party
Yeah.
doing business in France. I mean, to your point. It could
Yeah,
be,
and I'm even to the earlier point about the DOJ wanting companies, I'm biased because I work in Latin America, but it's, Africa, Latin America are kind of the final frontiers in terms of global economy and expansion of business. And if we do want the regions to develop in a good way and really prevent corruption in other parts of the world, companies have to go in with the right resources and the right professionals to effectuate change.
Well, and that really raises an issue, right? Because from a business's perspective, they want to go into a country and feel like there's some certainty that they can do business fairly and honestly, not put themselves at risk. They also want to know that if there's a legal dispute that they're engaged in, that there's a legal system that will adjudicate it fairly, and a judgment that they may get would be, enforceable. It really is not just about U.S. enforcement of the FCPA law, isn't it? It's really about countries throughout the world. Marta mentioned the Clean Company Act in Brazil, but the number of countries that have adopted similar laws over the last 10 years, in part because they're incentivized under treaties to do so, but it has really grown, hasn't it? So how is it? Are we seeing an increased coordination then among countries, the law enforcement groups in countries, to go after a particular problem?
Yes, and the numbers really bear this out. Over the last 2 years, there have been 9 coordinated resolutions with foreign authorities. And contrast that with, in the prior history of the FCPA, there were like 2 or 3. So in 2 years you have 9, and it's not just with the UK or a partner. You might say, okay, well, for quite a while we've been working with the SFO. It's the UK, France. The first coordinated resolution was with France earlier this year in the SOCGEN resolution, Singapore, Brazil, the Netherlands, Switzerland. And with Brazil, obviously there's been a fair amount of attention on that, and they've passed new laws, and you have an increased focus on that. And I think you're going to see more of that. You have the OECD working group on anti-bribery. 44 members participate. There are 4 meetings a year. There are 2 law enforcement meetings a year on that front. And you have a fair amount of dialogue with countries as well and their law enforcement representatives with DOJ, because the FCPA has been around for a long time. It's 41 years old, and there's a lot of experience in this space. So these foreign regulators from these countries that really want to improve their enforcement in this space, they come over. They do participate in trainings. The SEC.
So you're sharing best practices with them,
and they want to know. And so there's a fair amount of dialogue, and that's leading to more and more cooperation.
and they're also benefiting from collecting part of these fines themselves as well, too, right? I mean, in the Netherlands example that you gave, I mean, these fines that Megan had talked about a little bit earlier, I mean, these are huge dollar amounts. So for a government to be able to collect a few $100 million, there's an economic incentive as well, isn't there?
Well, there is an economic incentive, but if you think about it in terms of the countries that have a lot of corruption there in the market, when you wind up having the amount of money that is returned to some of these markets, it not only encourages them to increase enforcement, but it also repays the victim state. The governments are being exploited through corrupt contracts.
So, Pablo, how does a company deal with this coordinated approach to enforcement? Do we? I mean, I guess at the essence, it's don't pay bribes, don't take bribes, right? I mean, at the very essence, if you had to have a 2-sentence policy, right? That would be it. Don't pay bribes, don't take bribes. But different countries, in fact, do have different approaches, especially when it comes to reporting. How does a company, deal with that when you're operating in multiple jurisdictions? I mean, Aon's one example, but I mean, the world, notwithstanding what some folks seem to be thinking or trying to do these days is more and more international. Commerce is more and more international. I mean, how does a company deal with that?
It's a complicated sort of road to navigate, in part because not all regulators see things the same way, and they don't all see the misconduct the same way, and they don't all have the same way of looking at sort of investigations that you do internally. Some don't want you to do it at all. Some want you to do it and self-report. Others are concerned.
So it's pretty simple.
Yeah.
It's pretty clear as to what you're supposed to do, right?
Right.
It's not at all, right?
Right. Others actually will be offended, if is the best word I can think of right now, if you don't tell them first, right? So then you're in a scenario where you have this information, it potentially exposes you to risk in multiple countries. Who do you tell first? Where do you get the most benefit for telling first, right? And if you get a benefit somewhere else, is that benefit going to extend to the other countries, right? Because they have their own jurisdiction. It may or may not. What I have found most effective in sort of navigating that is to open a dialogue with the government and to try and get the government to bring all the parties to the table. Rather than you try and individually navigate each of the different countries, the governments actually have open dialogues, open lines of communication with each other.
But
So-
when you say the government, does that mean
That
is you're
means-
instinctively going to the U.S. government, or it could be any other government? And
Depends where your
picking-
risk is, right? You got to do
Okay.
you got to do some analysis, right? But let's assume your risk is such that you could potentially face fines by the U.S. versus, let's say France, right? And if you know France is less likely to enforce, or at least has a lower sort of prosecution sort of delta, if you will, right? It just doesn't do as many cases relative to DOJ, right? Or is not likely to look on a U.S. company before a French company. Like, there could be a variety of factors. But wherever you are, you say, look, I'm likely to end up before DOJ at some point, and when I end up before DOJ, this is likely to be the result given what they do. Is there some benefit to going to them first, self-reporting, and in the process of cooperating, seeking their cooperation with other countries in order to bring everyone to the table to figure out how, amongst the governments, they view the loss associated with this misconduct, so that they can all globally resolve this at once, so that you don't end up hopping from country to country trying to solve the same problem in different countries.
I mean, it seems to me that given DOJ being sort of the big dog on the block, and even if a company is not a U.S.-based company but has a significant U.S.-based presence, and any really significant international company is going to have a big U.S.-based presence because it's a big U.S. market. So you've got to be aware of what the regulators in the U.S. DOJ is going to do. It seems to me like the gravitational pull is going to be toward Matt. I mean, is that...
I think that's right. I just wouldn't say that it always pulls towards
Right.
Matt.
Right. There are times, and I think you have to kind of be careful too that you want to make sure that DOJ isn't thinking that you're sort of gaming them by saying, I went to these people in, wherever it was,
Right.
Sierra Leone, and made a disclosure to them, and I thought that was fine. They seemed to be okay with it. There was no problem there.
I told them to tell you. They didn't tell you?
They said they were going to tell you.
That's right.
I think you have to be careful because,
Right.
I don't know Matt well, but it seems to me he wouldn't take very kindly to that.
No, I think that's right.
I think that is...
The danger, of course, is that they feel that you're trying to self-report to countries where you'll get the least punishment.
Right,
And
which
you
is the
won't
logical thing to do, by the way.
And you won't get caught by them.
Yeah.
Right? So when you try and do that and come to them, they're like, well, you didn't sort of come to us, so we're not going to view your conduct as voluntarily self-reporting. It was likely to come out anyway because of the other government. Or we won't view it as cooperation because you actually tried to game us by trying to go to another country to get a resolution to negate our ability to prosecute you for the
Right.
same conduct, right? So you end up losing in the long run.
Yeah, so I think it is tricky too because, just in terms of, in-house counsel, you have increasingly sophisticated in-house counsel on these issues, I think. I think you find now there's sometimes more expertise inside than there is outside, in various companies. But when you're dealing with these kinds of issues where they are global issues, it's virtually impossible for a company to have all that in-house themselves, to have that expertise. And it's not always easy to find a lawyer, really, that can, navigate that you're actually creating teams of people, that you're you're going to, and hoping that you're finding the best lawyers in each jurisdiction that can guide you, not just on the law, but also give you a read on what the enforcement attitude is. Because what's on the paper is one thing, but what is in the person's mind and how they react to things is quite a different story. We've all gotten these emails saying that if you want to be removed to our list, we are fully compliant with the GDPR, and just click here, and so that's on all of our minds with the European data protection and global data protection issues that are out there now. Marta, how does that affect an investigation? You take EU companies really treat these things differently than U.S. companies. Here you are trying to go out and do the right thing, conduct an investigation, get the information, and Matt and everybody else and Megan, when she was sitting a few blocks away at 219 South Dearborn, said, well, it's very nice that you told us that there's a problem, but if you really want to get credit, you've got to give us the details about what was the conduct, when did it occur, who was involved in that conduct. That's what they really want to know, who was involved. We're going to come to that in 1 second, because what they're going to do with that person when they find out about it. But I mean, how do you deal with that if maybe then you're constrained from conducting the level of investigation that you want to conduct?
So you're talking about cross-border investigations?
Yeah.
Yeah. It's tricky. I think, obviously hire good external counsel, but also think in terms of protecting your own firm, because you may not be able to transfer, documents from Brazil to Poland without running afoul of data privacy and also employee consent. I mean, you might end up inadvertently exposing your company to huge liability with one of your own employees who never consented or who didn't consent for that information to leave the borders. I think there's a couple of things. I think having good in-house counsel involved that is willing to travel to the place where there's a problem and actually reviewing documents there. So then therefore you avoid emails and exchange of information cross-border. I think that's one way to attack the problem. I think another way is to sort of regionalize the problem. So if you have external counsel looking after the problem in Latin America and then US and then Europe, and obviously somebody coordinating all that together, but essentially establishing different rooms, data rooms of information and then protect yourself against running afoul of GDPR considerations. And then, of course, privilege. Common law countries have a very different sense of privilege than civil law countries, especially for in-house counsel. So you have to be really careful you don't inadvertently run into a trap there either.
And that's another issue that we'll talk about that came up. Matt mentioned the SFO, which is the Serious Fraud Office in the UK. And there's a case that is pending now before the UK Court of Appeals called Eurasian Natural Resources, in which an internal investigation was being done by a company, and material that in the U.S. would be entitled to work product protection. There's very little doubt, that it would have been in terms of the lawyer's notes and other things that were collected in connection with this investigation, were deemed to be non-privileged under what the UK calls the litigation privilege. And so the number of investigations that we're talking about, like Rolls-Royce, for example, LIBOR, things that are happening cross-border, litigation too that happens cross-border increasingly, there's a complication there because as a lawyer, you may be going down a path thinking that my investigation, my notes, my mental impressions are all going to be held confidential, but in fact, they may be disclosed or be required to be disclosed in the UK, which would then cause it to that information to lose that privilege protection in the US, right? I mean, that's a tricky situation.
Well, we're getting to choice of law issues when you talk about the ENRC case, and that is, I think, still pending on appeal in the UK. There's the related RBS case that went a little bit in the opposite direction. But it actually complicates things a little bit from the perspective of DOJ. If you think about sort of historically, DOJ's been down the road of dealing with privilege issues and privilege waiver in terms of the Thompson memo and the McNulty memo, and then that's sort of being put to rest in the Philip factors reforms in 2008, and it's department policy not to demand privilege waiver or access to work product protected information. Now, if there's waiver, it's a different issue, but here we're talking about what the U.S. law is versus the UK law.
Right.
And you still have the issue of if you get materials that are protected under U.S. law from the SFO and it taints the DOJ investigation, you have a major problem. It's just like anything else that you really should not be getting access to because of whether it's Fifth Amendment issues or whatever that might taint your investigation.
That precise issue has yet to be litigated here in the States, to my knowledge at least. But that is, I mean, that's a real issue because you're at risk too. You don't want your investigation jeopardized. And I mean, and truthfully, I mean, Joe, all kidding aside, I mean, the government does respect the notion, right, that in the United States system, we believe that a client is entitled to have a lawyer that's free to develop facts and think thoughts and make notes. And, it actually promotes compliant conduct, right, law and law-abiding conduct if a lawyer is free to do those things. That's, the essence of the work product doctrine. So, I mean, I think it's kind of a tricky situation. We also have an interesting development, too, on that enforcement front in that the new director of the SFO, enforcement of the SFO, used to be an in-house lawyer at the FBI and someone who was an American. And so I think we'll see even closer coordination going forward on that. All of this raises an interesting issue, and Megan, I'm going to ask you this question since you've sat here very thoughtfully, took all of this in throughout this after giving a wonderful presentation at the outset. Is compliance and really something, are these FCPA issues really something that belong and to be owned by the law department, the in-house lawyers, or is it really something that's a business issue that extends beyond the law department?
It definitely extends beyond the law department, but I think that in-house counsel really have to own the issue, and they have to guide the corporation and seek the appropriate advice and recommendations throughout the process for any sort of business decision that ultimately implicates the FCPA. That's the only way to actually provide proper advice to your client, which is the company for which you're working. And the close coordination also ensures that compliance knows what's up and what's happening, what are the newest and latest and greatest trends within enforcement, within investigations, and to ensure that the compliance program is actually robust, it's effective, and that the flaws can be recognized and remedied so that we don't run afoul of what Matt will ultimately be looking for.
Marta, does your chief compliance officer report to the general counsel, or do they report to a different executive in the company?
No, she reports to our general counsel. I agree completely. I don't know that as lawyers you can sort of divorce yourself of compliance. I mean, at the end of the day, compliance is ethical behavior, and we take an oath to serve our clients ethically. To me, it's a little bit like the financial planning analysis finance person and the controller. I mean, they both are an independent controllership function, and they both should be looking at compliance. I think in many companies, for me, I run legal, compliance, and regulatory, as does my team. I think, 10 years ago, this FCPA journey, and the lawyers were sort of the natural people to look after this. And then as the programs became much more mature, lawyers are not project managers. Lawyers, are very good thinkers and substantive, advisors, but we're not the best at being organized and rolling out programs, and we're not marketing people, we're not communications people. So I think what's happening lately is sort of a move, as Pablo said, to sort of embracing other non-lawyers that might have a better skill set for, rolling out a meaningful compliance program and technology and data and analytics. So I think ideally the merger of both those things makes for a really good compliance program. I also think there's sort of a tendency these days, and I have my own feelings about it, first line of defense, second line of defense, third line of defense, right? The business at the end of the day has to own it, and they have to understand why compliance is good for business, why ethical behavior is the right thing to do. Then, law and compliance being the second line of defense, and then finally internal audit. But I think ultimately it's a combination of everyone, top down, bottom up, living and breathing it, and being able to market it in a way to your internal clients that they understand why this is good for business. And, being a glasses half full person, I think we are getting there. I think there's been a lot of lessons learned, a lot of, Megan's presentation at the beginning with all the fines that have been paid that, I think companies are no longer in a position where they can stick their head in the sand and pretend that it doesn't exist.
Pablo, are you seeing, if you, again, this last year you made such a big study of all of these things, bringing together these various constituencies. Are you seeing a trend with the chief compliance officer reporting to either the CEO or perhaps a CFO, or is it still more often to the general counsel?
You know, I think there are a lot of different models, and I'm not going to say that any model is better than the other. If I think about sort of who should own it and sort of what the most likely way to have a compliance function be effective, I think it should be owned by the board and the management, because they control sort of how it is a message gets percolated throughout the entire company. And I am seeing, as a trend, more boards adding compliance people to them. Wanting to have access to that level of information at a critical point in time, rather than waiting until it comes up the stream. So as long as boards are taking a greater sort of responsibility on understanding how compliance works and making decisions sort of real time with that input, I think you're more likely to have a culture of compliance and a company that values sort of ethics and good conduct, rather than wait to see if they can.
I would just add, I think you raise a good point. I think independent of lawyers also owning compliance, there is something to be said for an independence function of a compliance officer that reports independent to the board. I do think there are situations where you're conflicted as a GC because you're looking at something from a commercial perspective, and there's some gray areas where the compliance officer can look at it from a whole different perspective, and even if it implicates C-suite individuals, which are the general counsel's internal clients. So your point is taken well, reporting independently to the board of directors.
It's interesting too that it's taken this long, frankly, because if you're thinking about good corporate governance and you're thinking about the creation of a board that really is there to advise the company, it's not just the CEO's pals, but a real board that is addressing the various needs of the company and bringing expertise from the outside. Given the level of risk, and it's not just the financial risk of the fines, it's the disruption to business, it's the demoralization of the people that work for you, it's the inability to recruit other good people to come to the company for a period of time because you're dealing with this crisis situation. It really is a very, very serious consideration, and it's taken a while for boards to get there, but I think you're right, Paul. We're going to continue to see more of that as we go forward. We have a few minutes left. You have assembled before you perhaps the greatest pool of knowledge at FCPA that is at least in this hotel. All right? So if I were you, I would take advantage of asking some questions of them if there's anything that's on your mind. Is there any questions? Sir.
In discussing whether to self-disclose and contact either as part of routine ongoing business or as part of an acquisition, it seems to me that you might be able to, and I hesitate to use the word, launder the acquired company through the acquisition, because the policy is saying, okay, well, as long as you're bringing it in and you're pushing out your policies to it and you're terminating what they were doing, then that particular problem will not be prosecuted. Is there anything strategic about the mergers and acquisition area to acquiring a company that has that problem so that they can get rid of it?
That's an interesting thought.
Yeah, no, I think that, first of all, the principles of individual accountability are a pretty hard reality for somebody to think about in terms of doing that, because even if you have a declination as to the corporate entity, if you are absorbing, for example, some of the profits, there may be a disgorgement obligation, but also you're going to have the individuals who were committing the wrongdoing held to account, and so you might, the notion that the corporation might not be prosecuted because of the disclosure and the openness and the cooperation, that doesn't mean that the wrongdoers individually will walk away clean. So if they think that the way that we solved this problem in our past 20 years of building a business based upon bribery is to simply sell off the business to XYZ Corporation, it won't work to their benefit.
There's still downsides to it.
Yeah, there's still down. I mean, this doesn't mean that the individual wrongdoer is going to pass or that the conduct won't be looked at. If it is, part of a grand conspiracy to basically sweep the whole thing under the rug, that's going to be revealed as well.
Gentlemen in the fourth row there?
Yeah, I was going to say, first of all, thanks for the concluding remarks about boards of directors. I think that that's a point that's well taken. And actually, I think as we have presentations like this, that sort of issue might be introduced a bit earlier in the discussion, because I think it makes for a more fulsome discussion. I would say this, though, that even when you're dealing with boards, you have them configured and dealt with differently, depending on whether it's a domestic company or international, or whether it's wherever it's domiciled. So that's something else that can add to the dynamic of that discussion as well. But very good job.
Thank you. Sir?
Yes, a couple of years ago, we represented an inquiry, unfortunately, it turned out to get the agricultural inspectors in the foreign country to look at the crops, paid gas, provided food, and an air conditioning unit. The facilitating payment argument didn't get us much traction. Is there any life left in facilitating payment?
It's a good question. Well, that's the final arbiter of what is a facilitating payment. For those of you who don't know what we're talking about here, is there is this sort of quote facilitating payment de minimis exception, but it's not spelled out. There's no list of what constitutes a facilitating payment. So, Matt.
So in this circumstance, I don't know what the volumes were in terms of the gas or the air conditioning, or what exactly that tied to. If it was something, you're talking about agricultural inspections.
Yeah, the company had to meet certain contractual deadlines to get the crop certified and out of the country and distributed. So
it sounds to me like there's some discretion in that decision in terms of the timing, in terms of whether there would be approvals or not. So the facilitating payment except, which I agree, it is not something that you're going to find applied often. It is an anomaly in the statute. It's something that you will not find, for example, in the UK Bribery Act at all. But it is intended only to apply to those things that you're going to get anyway. And there's a de minimis or a small facilitating payment in order to get you that which you would already get anyway, but maybe a little bit faster. That is not an exception that you're going to see spelled out and relied upon by the Department of Justice. There's going to be quite an uphill battle on that in terms of when it will apply or not. And I think in large part it's because in bribery schemes that come to light, we aren't talking about small token gestures to speed things up. These are payments to acquire business. These are things done to influence customs officials to look the other way. And the notion of providing smokes and cokes to somebody to wind up having them just check a box a little bit faster, that's not a case that would be prosecuted by the Department of Justice anyway.
There's Chicago, as all of you know, we've had our share of corruption. There was a judge who had a philosophy that if it could be consumed in one sitting, it could not be construed to be a bribe. So he also had a philosophy that if you don't know the difference between your friends and your business, you don't deserve either. So that's true too. This has been great. Thank you all.